Good afternoon. Good afternoon. We're going to go ahead and get started. Good afternoon and welcome to the O'Donnell Consent Decree public meeting. My name is Dr. Natasha Willis and I am the Program Compliance Manager with the Justice Innovation Team at the Office of County Administration. For those of you who may be attending a public meeting for the first time, following a class action lawsuit against Harris County claiming that the misdemeanor bail system was unconstitutional, a settlement agreement was reached known as the O'Donnell Consent Decree. The consent decree represents the first federal court supervised remedy governing bail. The mandate requires oversight and accountability of Harris County and all parties involved. All parties recognize that the input and involvement of Harris County residents are essential to meaningful and lasting reform, which will be effective for ongoing system monitoring. As a result, we hold these public consent decree meetings. To read the consent decree, annual reports, or other related O'Donnell information, please visit oca.harriscountytx.gov. We are entering the 7th year of the 7-year consent decree. Here today to provide an update on the consent decree implementation are independent court monitor Professor Brandon Garrett, Deputy Monitor Sandra Gita Thompson. With them is the Honorable Judge Ashley Geis, representing the County Criminal Courts at Law, Attorney Rachel Frazier with the Harris County County Attorney's Office. After the updates from the monitors and parties, we will open the floor for public comments and questions. With that, I will turn the meeting over to Professor Garrett.
Again, it's an honor and a pleasure to be back in this Commissioner's Court with Sandy Guerra Thompson and the judge and the County Attorney's Office and so many of our collaborators here in the audience. It's time flies. This is the last year of our 7-year term reporting to the federal judge in this case about the progress under this consent decree. And while our final report won't be filed with the judge until March 1st, we're here a little bit early, but for a good reason. The findings look very much like what we described to you when we were last here in this room a little less than 6 months ago in terms of the data regarding different aspects of the misdemeanor system in Harris County. And if anything, the positive findings that we reported last year have deepened and look still better now that we have information about all of the misdemeanor cases filed in 2025. So it's a new year. Happy New Year. And what we are seeing is that the number of misdemeanor cases filed against people has declined a little bit. There's been a somewhat steady decline in the last few years. We often get asked first about the public safety aspect of this, how many people come back into the system. In our detailed report with tables and statistics, we report several different measures, but one simple measure is just how many people have a rearrest for anything, a misdemeanor or a felony, within a year. And we continue to see a modest decline in the numbers of those people. And basically the same percentage has been observed for several years now. Same percentage of people who are rearrested for a misdemeanor, same percent as a felony, and smaller numbers overall. So all of that is really good news. In terms of some of the most serious misdemeanor cases, one thing that was concerning, and I think the public was aware of this too, there was a spike in both DUI cases and domestic violence cases during the pandemic. And those two categories of cases went up in terms of numbers during those years. We've seen them steadily go down in the years since, and we saw the same last year. And in general, we've seen a decline in the percentage of cases that we call carve-outs under this consent decree, the more serious misdemeanors that go to a bond hearing in front of a magistrate. And so in general, we're seeing fewer cases, same percent, but fewer people that are repeat offending. and fewer of the most serious misdemeanors. All that is really, really good news. We'll hear from the judge shortly, but to just describe one aspect of the data that really focuses on the courts, um, it was not good for dockets to have a pandemic when courts couldn't operate like they normally could, and and we certainly saw that the time it took to process cases went up quite a bit in those years immediately during the pandemic. But we've seen a steep decline in the number of cases that take more than 3 months, 6 months, a year to process each of those time periods. And we're now at the point at the, in a new year, 2026, where last year, just to take one measure, the number of misdemeanor cases that proceeded to some final outcome in less than a year was almost the same as it was way back in 2015 before these bond reforms. And I don't think anyone would have expected that. It's really quite remarkable. And so we've seen a steep drop in the time it takes to process cases. A few new things that we talk about in this report that's coming out in March. One reason why we're here a little bit earlier than usual, usually we host the public meeting once the final version is filed. A lot of what's in that report is familiar, and it's just updated numbers, which have, as I've described, moved in a very good direction. They're similar to the last report, but a little bit better, and that's wonderful to see. One reason we're all here early is that, as many of you know, Professor Garrett Thompson teaches at University of Houston Law Center, and their law review is hosting a symposium about bail reform in Houston. Not just about the work done in the O'Donnell case, but about that work and also perspectives on bail reform from people around the country. And so we thought joining the two events made some sense logistically, but also symbolically. And some of the new findings that are in our report are also being are planned to be published as part of that issue. Those findings reflect the work that our colleagues at PPRI at Texas A&M, Dottie Carmichael and David Shee, have been working on for many years, and many of the stakeholders in the county have shared detailed information with them so that they could create cost estimates around what are the estimated cost savings or increased costs around the reforms that were introduced with Rule 9 and the O'Donnell consent decree. And so that work is finally completed, and it took about 6 years. But those cost elements are in place, and we see substantial savings per case under this consent decree. Some costs absolutely went up, other costs went down, and on balance, the findings suggest that there are many hundreds of dollars saved in statistically similar cases. The progressions are detailed, and there are lots of tables. But also importantly, actually, because they're looking at a multi-year window around cases being finished, those cost savings that we describe in our report reflect data that's a few years old. And so since that we've seen the time it takes to complete cases, the number of settings in cases, a lot of the efficiencies that we've seen have continued to deepen in the last few years. The cost savings may be still greater if we would look at it a year from now or 3 years from now. And so all of that is wonderful to share. We also want to talk about some of the work that's being done to improve other aspects of the system. And the county has rolled out court appearance notification systems and also information online about how to figure out what court you're in and what's happening next in your case. Additional work is in progress and much closer to completion around that. Work has been done to update the trainings that are provided on different aspects of misdemeanor bail procedure. Those have been offered for years now, but there's been new work done to put those in place in an ongoing way. And we also want to call out really important work that's been done to try to identify cases that could be diverted at different stages or people who could use additional support or advice to help to navigate the misdemeanor process. And so, we've tried to highlight all along that this, Rule 9, the consent decree, some of the rules about which cases have bail hearings, which don't, that's really only one part of the work that has been done to try to bring improved practices and resources to misdemeanor cases at every stage, whether it's indigent defense once a lawyer is representing a person, whether it's thinking about screening the cases early on, or thinking about court appearance and promoting getting to court to resolve things that do need to be resolved in court, or non-appearance if the person doesn't need to be in court and their lawyer can handle it. Uh, some of those projects really did take some time. It wasn't as simple as putting into place a new rule. As lawyers, we know how to follow rules, and if a rule changes, we follow it. But a lot of these other supports really required investment and people. And 6 years in, it's been wonderful to see all of that hard work by so many different folks in the county pay off. So that's kind of the quick overview. It's pretty similar to what we've described in the past, but really good, better. And so it's a pleasure to be able to share that with you and also share some new findings. Sandy, do you want to share some additional updates as well?
Hello. Yes, I'm Sandra Guerra Thompson, as Brandon said, a professor at the University of Houston Law Center. And we are really excited about the upcoming bail reform symposium that we're hosting tomorrow at the Law Center. It's open to the public, and you can find us online if you look for University of Houston Law Center Bail Reform Symposium. It's been a really interesting and gratifying. We at the Joint Processing Center, where people are taken when they're in custody upon an arrest, and had the privilege of watching an interview of a person who was about to be released, who was being offered services by the Community Assistance Referral Program, a person who was there and who wanted to make sure that every individual knows where they're supposed to go when they have a court date, how to find that information online, and they're given information when they leave in a packet. They're asked about transportation, if they need a bus pass to be able to get home safely. If they don't have food, they're directed to shelters. And they're also able to identify whether that person is in need of referral to other, psychiatric or medical attention that may be needed. So it's really exciting to see this development, which is all coming from O'Donnell. These are some of the services that Professor Garrett was talking about that are part and parcel of what we're doing here, monitoring the county's progress on so many different fronts. We also had a really excellent meeting with District Attorney Sean Tier and his leadership staff, and learned about a lot of the very interesting work that they're doing to try to make the process more efficient, and to make use, for example, of an alternative to arrest known as cite and release. So for very, very low-level cases that really don't merit taking a person into custody, the district attorney is encouraging law enforcement to use the cite and release process as a way of treating some of these cases much like you would a speeding ticket, where they still have to come to court and they still have a criminal case, but they don't necessarily have to go through the whole arrest process. And so looking for other ways to make the system more efficient, to reduce the number of people in the jail, and thereby to reduce cost for taxpayers, but also to relieve some of the conditions that really create safety and medical risks for the individuals being housed. So it's been a very interesting and exciting morning for us so far. We look forward to more meetings this afternoon. We hope to see some members of the community. For the last 6 years, we've been working with community advocates who provide assistance for people with mental illness, who are survivors of domestic violence, who are immigrants, who are homeless, and as well as civil rights advocates, law enforcement representatives, veterans representatives. So a wide variety of what am I looking for? Demographics in our community, who we try to talk to about how the work in O'Donnell affects the individuals they serve and how we can improve, how we can help to improve the processes that are in play. So look forward to meeting with more individuals today, and thank you all for your attention. I'll turn it over to Judge Geis.
Thank you. Good afternoon. My name is Ashley Mays Geis. I serve as the presiding judge for the 16 Harris County Criminal Courts at Law, and I also provide over Harris County Criminal Court at Law number 12. I want to thank everyone in attendance today. Your presence reflects a shared commitment to this work, and we appreciate your continued interest and engagement. I'd also like to thank two groups who have played a key role in this process. Of course, first, thank you to the monitors. Thank you for your continued work in documenting our compliance and our progress. And to our justice partners, thank you for your collaboration and ongoing commitment to working with us as we strive to ensure Harris County has a constitutional bail system. I'll begin with a brief update on the current caseload in our county criminal courts. Access to timely justice is imperative, especially in our criminal courts where personal liberty is at stake. And over the past several years, we've put a sharp focus on increasing our efficiency, clearing cases, and reducing the backlog. That work has ultimately paid off. We've drastically cut the misdemeanor case backlog, making justice more timely and accessible for the people who come before each of our courts. We've since shifted our focus to reducing the number of active cases pending. I'm pleased to report that we've made meaningful progress here as well. We've cut the average active cases pending by 2/3, going from a high of almost 3,000 per court to now just an average of right about 993. And I also want to thank you, Mr. Garrett, for recognizing the results of the judiciary's efforts at reducing the time that it takes for these cases to get to their ultimate resolution. I also want to provide an update related to our misdemeanor bail reform work. The Harris County Criminal Courts at Law continue to be committed to ensuring safe and effective bail reform. Misdemeanor bail reform is designed to level the socioeconomic playing field, and it ensures that no one remains in jail simply because they cannot afford to pay bail. The black letter of the law tells us that bail is not meant to be a tool of oppression. Its primary purpose is to promote public safety and ensure defendants who are presumed innocent under the law return to court. Rather than focusing on the ability to pay, bail reform allows us to focus on two key issues. One, is this person considered a danger to the victim or to our community? And two, what is the likelihood that this person will return for their future court dates? When necessary, appropriate bond conditions such as protective orders, pretrial supervision, and other very tailored requirements are used to help mitigate potential risks. The goal is to utilize conditions that are effective at mitigating risk, but not excessive. And that concludes the update from the county courts at law today. Once again, thank you to the monitors, to all of our justice partners, and to all who are in attendance. This work is very important, not only for the courts, but for our justice system as a whole and the people it serves. We appreciate the opportunity to be here, and we look forward to any questions. I look forward to any questions that you may have. Thank you.
Good afternoon. My name is Rachel Frazier, and I am here on behalf of Jonathan Baumbaum, who is the Harris County Attorney. I want to join Judge Geis in thanking the monitors and all of the stakeholders and everybody who has contributed and done so much work over the past 6 years, which I can't believe it's been 6 years. It seems like 6 minutes. So at the county attorney's office, we work with the stakeholders to help ensure implementation of the consent decree. And our role is to provide legal advice when needed. And we're committed to seeking justice and ensuring that the misdemeanor bail reform. Thank you.
Okay. So thank you so much for that review. We will now begin the question and answer portion of this meeting. We'll start with in-person questions and then take questions from our online audience. For in-person attendees, if you have a question, please come to the podium, state your name and affiliation into the microphone and ask your question. For those online, please list your question, name, and affiliation in the chat so I can read them out loud for the panel to review.
We know it's early.
Right.
You know,
So
really, the real reason we wanted to do this in February is that in March, the March Madness tensions can really grow between Duke and University of Houston. So we just, yeah. So, but maybe people mostly come because they want to see that.
let's see. We have about 48 people online. So we will now, I don't think we have any in-person questions. So for my online audience, if you have any questions, please list them in the Q&A portion of the Zoom. We'll see if they don't see any questions just yet, but oh, okay, let's see. Okay, so we have Katharina Deckhart in the chat, and she's with Tahare Justice Center. And she's asking if you could talk a little about how domestic violence cases fit into this framework and what a bail hearing looks like in these types of cases.
Right, or you can add. I guess I'll start that. Oh, no, I don't know. I mean, domestic violence cases do proceed to a 1517 magistration. And there are certainly distinct issues that a magistrate will be digging into in a domestic violence case. We certainly also see that there are a different range of conditions, including protective orders, which are highly relevant in domestic violence cases. I mentioned that we have seen a steady decline in the numbers of those cases in the misdemeanor space over the last few years, which is positive, but that doesn't obviously necessarily mean that there aren't many extremely serious ones. The other piece of that is that once cases proceed to the criminal court and move forward, there will also be much more attention to supervision and conditions in those cases. There's just many more conditions that are irrelevant in a domestic violence case. That was one of the topics that we were talking about with the DA's office. There are obviously specialists that focus on domestic violence cases on the prosecution side, and they raise unique issues on the defense side as well. Some of those issues are common to domestic violence felony cases too, right? It's working with victims raises special challenges in domestic violence cases, and the social phenomena of domestic violence and the concern that it can escalate in some cases, and the challenge of predicting which are those cases where we're especially worried about that escalation. That's a challenge that faces everyone, whether it's the judges, the magistrate initially hearing about the case, prosecutors initially screening the case at intake, prosecutors and defense lawyers working on the case later. So these are some of the most important and challenging cases that anyone in the system works on. And while it's potentially good that we see modestly fewer of them, and hopefully that trend continues, there's always the concern that there are cases that don't get reported, and there's always the concern that that violence can continue in the face of conditions. And so these are challenging cases. That's the reason they do receive special attention under the consent decree. They're singled out as cases that go to magistration. Um, but there are, you know, a lot of resources and approaches to those cases that are really outside of this consent decree, in that those kinds of supports are not about what bail is set or what conditions are imposed, but what other things that you can do to make sure that that victims are protected and that good solutions and outcomes occur uh, to prevent domestic violence from cycling.
Yeah, and I would just add, just to step back a bit, just that the O'Donnell consent decree, we talk about misdemeanor bail reform. And while it does provide an avenue for many people to be released from custody without having to pay for their release, but some of the offenses are carved out to go to that magistration that Professor Garrett is talking about. And family violence cases are one of those types of cases. So those, in a sense, are not really part of the bail reform, because those are going to go through the normal process of going to a magistrate hearing. And in our conversations with District Attorney Tier this morning, we talked about the kinds of risk assessments that are done by law enforcement, and also, can be informative to the prosecutors to determine which of these cases are the most serious, where someone is really at risk of harm, seriously harming or killing a survivor. And he also wanted, especially for witnesses, for survivors who are immigrants, for all people really, to know that if they report an offense to law enforcement, that his office is now distributing these cards that will indicate to anyone who, if they get stopped by any kind of law enforcement, that they are material witnesses in a criminal case, and that there's a phone number on it where that can be verified with the district attorney's office. So they really want to encourage survivors to continue to call for help from the police, and they're doing what they can to try to make sure that, as material witnesses, that they will be accorded whatever protection the law provides.
And if I can also add, those cases do then land on our dockets for a bail hearing setting. And there's an additional layer of review because although a short amount of time has passed, by that time the case has been assigned to a prosecutor in one of our courts. They've had an opportunity to at least review a minimal amount of information about the case, maybe reach out to the complainant, and they are able to present that information to the court, at which point a trial court judge will then review the bond that has been set, as well as the bond conditions that is set. And so I just wanted to make sure, I wasn't sure if the question was addressing what does a bail hearing look like specifically for domestic violence cases, or what it looks like in general. But there is indeed additional individualized attention paid to the case once it hits a trial court's docket.
Thank you so much. Okay, question from Joy Davis. So with this current political landscape, what are some of the attacks or things that we can expect or maybe are already happening in relation to the decree or the targeting of the decree, if any?
Well, one thing that I didn't mention, because we are somewhat out of this as monitors, that the parties are now part of litigation before the federal judge. And there has been a motion to modify the consent decree to reflect changes in Texas law, and as well as a proposal to vacate it, I guess. We're not part of that briefing. We are independent and report on the progress of the consent decree to the federal judge. But I understand there's a schedule and there's motion practice, and that those motions are being considered in the court. The only rule that we had was that several of the judges reached out to us last summer with a specific proposal to make a change to Rule 9. At that time, we didn't feel we could give a thumbs up or down on it because the other judges weren't in favor of it or wanted to consider other proposals. And it takes more than just a handful of judges to make a change of that significance. And so we reviewed that proposal and thought that we couldn't approve it given the lack of sufficient judicial support. But since then, there have been filings in court. We're not a part of that process. We're just aware that it's happening. In terms of the other pieces of the big picture, like I mentioned, this is the sixth of our 7th year. So our term as monitors, we were appointed to do this work and to report to you all and to report to the judge for 7 years. However, the consent decree itself, unless it's modified or vacated in court, remains in effect. And so, that will be between the parties and the courts what the implementation looks like, assuming we finish our 7-year term and we're not renewed, or there isn't some other monitoring system that's put into place. But our role is time limited. The consent decree isn't, but it depends on what the parties and ultimately the judge decides to do.
And if I might add, of course, I can't comment on any pending litigation, but what I can say as a representative of the county courts, criminal courts judiciary, is that we always remain committed to following the law, number one, and we are always committed to public safety. In my earlier commentary, I mentioned that the law tells us that bail is not to be used as a tool of oppression. We follow the law. We consider all factors that the law requires us to consider in making our decisions. And so to perhaps answer Ms. Davis's question, nothing about litigation will ever change the judiciary's position on those two ultimate things. Again, following the law and ensuring public safety.
Thank you. And Brandon, I feel like you were kind of speaking to this next question. So an attendee had mentioned, as far as you're talking about your monitorship in 7 years. And so it states that while the monitorship is limited to 7 years unless extended for a good cause, the consent decree remains binding and in effect after the monitorship expires. And so I think something maybe I said they were asking for more clarification. So for those, again, just in general, so there are certain mandates that are in the consent decree, such as public meetings, trainings. Are those things expected to continue after your monitorship, or is it just the implementation of Local Rule 9 that is expected? I think we get a lot of questions like that.
My understanding is that our monitoring role is time limited, but that the supports for court appearance, many of the other aspects of the consent decree are not time limited.
All of the requirements of the consent decree are still in effect until the court says that they're not. The only thing that changes is that we're no longer in the role to monitor that work.
And also, for example, the non-appearance funds, they did put a time limit on those. So if there's a time limit stated in the consent decree, then there's a time limit. But if it's not, then it would continue.
Oh, right. If there's a time limit on funding, yes. Yeah, that would.
Okay. Yeah. Okay. Next question. How will the positive changes be sustained beyond the O'Donnell timeline? So I think kind of similar. It seems like, again, things will continue unless a court decides.
Yeah, I mean, I think that's a great question. And one of the things that we were required to keep in mind as we monitored was, how permanent are these changes? And one of the reasons that we agreed to become monitors in the first place is that we saw a great deal of consensus among stakeholders in Harris County. And I think when you have like the judiciary, as is shown here with Judge Geis. We've had other of her judicial colleagues in the past, all been very supportive. The Harris County Sheriff's Office, the County Attorney's Office, and now even the District Attorney's Office. very supportive of the work that's being done, because again, these are the low-level misdemeanor cases, right? Most of the time when people are talking about bail reform and when there's a great deal of angst about it, they're really talking about felony cases. But by reforming the lower level offenses, this is the lion's share of the caseload. So we can have huge efficiencies by treating the lower level cases in a more evidence-based and sensible way. So that's really what I think we're doing, and so yeah, we're just looking forward to continue this work until our time is up. But I think most of the things that are happening are happening because local stakeholders want to see them happen. And I mean, I really have to send a shout out to the county attorney's office for their work on the non-appearance mitigation of helping people to get back to court, and the so many sensible changes that have been implemented. I don't see these things going away. And so I feel really good about that personally, and I expect that there are a lot of other people, good people working in Harris County who are pleased to be really creating a much more effective system.
I was asking if someone could explain exactly what a bail hearing is.
Would you like to, Your Honor?
I guess I'm the only person up here who does them daily, so I should answer that. So a bail hearing is when we bring the defendant out, of course, with their attorney. And I say out because if you're set for a bail hearing, that means you are in custody. Typically, you fall into one of those carve-outs. And the defense attorney will give us more information about their background, about their ties to the community, all of the things that fall under 1517 and what we must evaluate in determining an appropriate bail amount. The state will offer information about the case, whether they've reached out to the victim or the complainant in the case. They will also give us more information about their criminal history because, of course, we're not able to see a person's full criminal history. And so the state is able to, on their end, run that and provide the court more information to determine that a judge would need to determine whether this person poses a risk, safety risk to either the victim or the community as a whole. And we allow argument. And of course, I must add that we do give the defense attorney time to meet with the defendant before we do all of this so that they can have all the information that they need available in order to properly defend the defendant and person accused. And so ultimately, the judge makes the decision under the law whether they believe the bail as set is appropriate or whether it needs to be increased or decreased. There are some times when a person is set for a bail hearing and they're completely fine with the bail as set by the magistrate and they'll waive their bail hearing. But that, again, is a decision that is made between the defendant and their attorney. But that's a very general overview of the bail hearing. It's getting a background of the case, of the person's. Another thing I must mention is we look into their history of appearance. That's a huge factor. We see if they have had prior criminal cases. We are able to look at whether they appeared as ordered in those cases, and that's a huge factor in determining what bail amount to set going forward. Typically, if a person, after evaluating all of the information, the court finds that they are not a risk to the safety of the community or the complainant, and if they do have a criminal history, it looks like they show up to court when they're supposed to, then and only then do we consider something like a PR bond, but that absolutely is part of the consideration. Oftentimes, a PR bond is what is requested in a bail hearing, but ultimately the decision lies with the court after proper evaluation of individualized information about that case and that defendant. Does the judge then make that determination?
Awesome. Thank you so much. We had a question where someone's asking just a reminder of when the monitor's report will be released.
March 1st.
March 1st. Okay. Last question. We have a question from Oz, and he works
March
from
3rd. No, I'm sorry. March 3rd. It's always March 3rd.
March 3rd.
After 6 years, is that right? Yeah.
Okay. Question from Oz from Harris County Universal Services, and they are interested in knowing what has been the biggest challenge that you all as monitors have experienced in the last 7 years. I don't think we've had one of those.
I mean, certainly we started our work 2 weeks after the pandemic hit, and to not be able to meet with anyone here in person, it took a lot of work to put together and develop code around the data that we needed, and to do all that virtually wasn't pleasant. A lot of life was virtual then, so it sort of fit with that. But a lot of the architecture and the planning happened between us and all the different plans that were developed by other county actors, the county attorney's office. A lot of the hardest work was done just when the pandemic began, and that wasn't easy for anyone. And just when the pandemic was imposing those really substantial burdens on the JPC, on the courts, on everyone who does this work around misdemeanor cases in Harris County. The MAC was launched not too long into that time period. Like, a lot of big changes and big projects were implemented during a time where it was really challenging for everyone to do their jobs. And so that was really remarkable.
It's probably a good answer.
Yes. Okay. Anyone from in person? Okay. Well, thank you so much. If there is nothing else, then that concludes our meeting. Thank you so much, everyone, for attending. We hope you have a wonderful rest of your week.